Okay, you can hear me in the jail?
Yes, Your Honor.
Okay. We'll start with Mr. Lino. On the record in the matter, the people of the state of Michigan versus Alcario Leon Lino. Counsel appearance.
Thank you, Your Honor. Amanda Tringle, Office of Public Defender, appearing on behalf of Mr. Alcario Lino for purposes of arraignment only.
Mr. Lino, today's the date and the time set for arraignments. I have several files here. We'll start with the felony file. I have a felony complaint. It alleges that on or about July 15, 2023, at the area of Christopher and Cross Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of weapons carrying concealed. The allegations are that you did carry a dangerous weapon, to wit a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, that being a Chevy Trax, and that this was done contrary to Michigan Compiled Law 750.227. That's a felony. The maximum penalty is 5 years and or $2,500 in fines, and a mandatory forfeiture of the weapon or device is required under the law. There's a count 2 of controlled substance possession of cocaine, heroin, or other narcotic less than 25 grams. Allegation here is that you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance cocaine, and that this was done contrary to Michigan Compiled Law 333.74032A5. That's a felony. Maximum penalty is 4 years and or $25,000 in fines. There's a count 3 of weapons, felony firearm. The allegation is that you did carry or have on your possession a firearm, that being a pistol, at the time that you committed or attempted to commit the felony of possession of cocaine less than 25 grams, and that this was done contrary to Michigan Compiled Law 750.227B. That's a felony with a maximum penalty of 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. There's a mandatory forfeiture of the weapon or device required under the law. There is a count 4 of weapons, firearm, reckless use. The allegation is that you did recklessly or heedlessly or willfully or wantonly use, carry, handle, or discharge a certain firearm, that being a pistol, without due caution and circumspection for the rights, safety, and properties of others, and that this was done contrary to Michigan Compiled Law 752.863A. That's a misdemeanor, and the maximum penalty is 90 days in jail and or $500 in fines. The court may suspend your hunting privileges for up to 3 years. However, there is an habitual offender second offense notice attached to that count. It says, take notice that the defendant was previously convicted of the felony or an attempt to commit a felony, and that on or about July 14, 2016, he or she was convicted of the offense of resisting, obstructing an officer in violation of MCL 750.81D1 in the 30th Circuit Court, Ingham County, State of Michigan. Therefore, the defendant is subject to the penalties provided by MCL 769.10, which enhances the penalty to 1 1/2 times the maximum sentence on the primary offense or lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charges in counts 1 through 4 plus the habitual offender second offense notice and the maximum penalty, sir?
Yes.
Okay. You have the right to be represented by counsel. You're represented today by Ms. Tingle from the Office of the Public Defender for the purposes of your arraignment only, but you do have the right to have an attorney with you to represent you at each stage of the criminal prosecution. You have the right to have an attorney represent you if you're questioned by law enforcement as well. If you cannot afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. Do you understand your right to counsel, sir?
Yes.
Okay. Okay, is he making a request for court-appointed counsel?
He is, and I'll get that application submitted to my chief for review.
Okay. Mr. Lino, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. If you stand mute, we'll proceed to the next action date. And in this case, there'll be a probable cause conference and a preliminary examination. You have the right to have a preliminary examination within 21 days of today's date, that being your date of arraignment. At the time of your preliminary examination, you have the right to have the prosecution meet their burden, which is to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. If this matter proceeds beyond, then you have the right to a trial, and you have the right to a jury trial. At the time of trial, you have the right to remain silent and not have silence be used against you. You have the right to the presumption of innocence, so you're innocent until proven guilty. You have the right to require the prosecution to prove each element of each of the charges being brought against you at trial beyond a reasonable doubt. You have the right to see, hear, question, or cross-examine any of the witnesses the prosecution intends to call. You have the right to call your own witnesses to trial or present evidence at trial that you believe further a defense to the charges being brought against you. Do you understand the rights that I've just iterated to you, sir?
Yes.
Okay, do you have any questions about those rights so far?
No.
You have the right to be considered for pretrial release from custody. We'll address your bond shortly. Are you currently on probation or parole?
Yes, I'm on probation here, I believe, in this court in 54. With Brandon Hannah, I believe.
Is your probation officer? I think I have some files here. Let's see.
Yes, correct.
Okay, you are on probation. For the purposes of today, we'll enter a not guilty plea on your behalf. You're currently scheduled for probable cause conference before Judge Cynthia Ward. It's going to be July 27th, 2023 at 8:30 in the morning. You can appear via Zoom for the probable cause conference, okay?
Okay.
And then you have an in-person preliminary examination scheduled before Judge Cynthia Ward. That's going to be on August 3rd, 2023 at 8:30 in the morning. Did you get your notice to appear?
Yes, ma'am.
Oh. Is your current home address the address on New York Ave?
Yes, correct.
Are you employed?
Yes.
Where are you employed?
BMG Construction. Or it might be under BMG Solutions, but it's a construction company.
Your phone number is the number ending in 4136?
Correct.
You're currently out on bond on a pending matter as well, is that correct?
I think I'm on bond for probation. I believe so. Maybe. I think it was for failure to appear for a sentence for 1 year. I believe I am.
Okay, I have here people of the state of Michigan versus Lino, file number 23-00148FY. The allegation in this matter is that you violated your bond conditions. The allegation here, let's see. You were placed on bond by Magistrate Milmore in that file on January 17, 2023. You were advised that you were not to use, purchase, or possess alcohol, that you could not possess a dangerous weapon or firearm, that you could not commit a crime while on release. The violation alleges that you did commit those actions, and that would be connected to the file that you were just arraigned on. So you have the right to have a contested hearing as to the bond violation. You have the right to be represented by counsel at that hearing on the bond violation. If you're found to be in violation of your bond conditions, your bond can be revoked. You can be sentenced to a term of jail. It is a contempt of court order if you violate your bond. And so you would be facing a maximum penalty of 93 days in jail or a fine of up to $7,500. Do you understand that?
Yes.
Okay. I'll enter a plea of not guilty on your behalf as to the bond violation. And have that matter set for a hearing, although may be delayed due to the pending matter of new case. I also have here in the same file 23-00148FY. Okay. So you're on bond before this case is before Judge Buchanan. You were supposed to appear for sentencing back on April 11th, and you failed to appear. This is a matter where you pled no contest to an attempted count 1 police officer resisting obstructing, and admitted count 2. Let's see. Police officer resisting obstructing. You were supposed to appear before Buchanan by 1:15 on April 11th, and you did not appear. Did you forget about your court date, sir?
Yes, I actually, me and my probation officer had discussed that. I actually called him and was supposed to go. I was actually supposed to show up to via Zoom meeting and get arraigned for that, but I ended up losing my phone and breaking it, so I just kind of didn't bother with it and just stopped even thinking about it. So, but yeah, I do know. I was aware that my PO had informed me that when I think the last time I spoke to him. So yeah.
Okay, your sentencing will be reset before Judge Buchanan on that matter. Let's see, people of the state of Michigan versus Lino, file number 20-01869FY. You were arraigned on a probation violation back on March 16th. You were scheduled on April 4th to appear for a hearing on a probation violation, and you failed to appear. The This is the violation that you were arraigned on, alleging that back on January 16, 2023, that you consumed alcohol. And there's also an allegation that on January 16th, you was at a bar or nightclub in violation of your bond conditions. You pled not guilty at the arraignment before Judge Buchanan. What happened, sir? Why didn't you go to your hearing?
Oh, it was my birthday the next day, so I didn't want to wake up in jail, so I just didn't go.
Okay, so we'll get that reset for you as well for your hearing for the probation violation. I have here people of the state of Michigan versus Lino, file number 21-02973FY. Again, the same violation. You were supposed to be in court for a probation violation hearing on April 4th before Judge Buchanan, and you didn't appear, but obviously it's the same reason. So I'll note that here for her records. That matter will also be reset for a new hearing. I think I got all the files better. And benchmark status, let's see, what is this? Okay, you can address bond counsel.
Thank you, Your Honor. I did have the opportunity to speak with Mr. Lino. He informs me that he is a lifetime resident of the Ingham County area. He is, he's advised that he is currently on probation and out on bond in another matter. He's indicated that he is employed with VMG Solutions, a construction company, and has been for the past 4 years. He does have family in the area. He does reside with his grandma and his mother. Understanding the very serious nature of the charges before the court, but also Mr. Lino's presumption of innocence, his ties to the community, we would respectfully request a reasonable bond, and perhaps in lieu of a higher cash surety bond, given the understanding that the court's purpose in setting bond is to ensure Mr. Lino's appearance in court and to protect the community. Perhaps consider offsetting a higher cash surety bond with perhaps a GPS tether if you have concerns about flight. Thank you, Your Honor.
Thank you. I've reviewed his prior criminal history, and in this new felony file, it's evident to the court, at least, that there's some concern about his willingness to appear in court. Even when he recalls that he has a court date, his judgment can be skewed if he thinks he has other things that he wants to prioritize versus appearing to court. I think we have 4 files here that had a failure to appear on it. Because of that and the serious nature of the charges in the present file, bond will be set to ensure his appearance. Bond in this file, the new file, is gonna be $20,000 cash surety. Bond and file number 21-02978. In which he needs a new probation violation hearing. He's remanded per the request of Judge Buchanan to see Judge Buchanan for his hearing. The PA 53 violation file on 23-00148. These are both for units, which is also a matter in which Mr. Lino has a bench warrant for failure to appear for sentencing. Bond is set at 10,000 cash surety. Make sure I got all these files. I think I got one more. 20-01869 FY, also a matter in which there is a probation violation hearing pending. Defendant will be remanded to see Judge Buchanan. While out on bond, because you're gonna eventually address these other matters that you're remanded on. And if you post bond, you have the following conditions in the new file. You're not to use, purchase, or possess alcohol or drugs without a valid prescription. You're not to engage in any assaultive or threatening behavior. You're not to travel outside the state without prior approval of the court. Not to possess a firearm or any other dangerous weapon. You need to report to pretrial services within 48 hours of your release. Do you understand that, sir?
Yes, ma'am.
And you need to make sure you come to all of your court dates. Do you have any questions about your bond conditions?
No, ma'am.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
You're all set, sir.
Thank you.
Your Honor,
Yes.
yeah, I'm sorry to interrupt you. You gave 4 bonds for 5 files?
One of them had the same file number twice.
So is it 10,000 for both of them then?
One of them is the same file, so it's only one bond. One is a PA 53, it looks like. Let's see here. PA 53, I have it's for file number 23-00148. And then I have the same file, 00148. He also did not appear for sentencing. So it's only one bond for that file.
Oh. Okay,
It's
so
only one file. It's one file, but essentially 2 violations, I guess, that stemmed from that one. He didn't appear to court, so there was a bench warrant, and then he allegedly violated his bond. So the bond in that file is gonna be
Together.
the 10,000, okay.
10,000,
Thank you,
correct.
thank you for the clarification, Your Honor.
Thank you.
No problem. Okay, let's see. On the record in the matter, the people of the State of Michigan versus Sierra Janelle Frederick, file number 22-01895. Council appearance.
Hello.
Thank you, Your Honor. Amanda Tringle, Office of the Public Defender, appearing on behalf of Ms. Sierra Frederick for purposes of arraignment only.
Okay, Ms. Frederick, today's the date and the time set for arraignment. I do have a misdemeanor complaint here. It alleges that on or about May 29, 2022, at the area of 6200 South Pennsylvania, City of Lansing, Ingham County, State of Michigan, which is Southside Meyer, that you did allegedly in count one commit the act of assault or assault and battery, and that you did make an assault or assault and battery upon the following person, that being a Jacqueline Jones Frederick, that this was done contrary to Michigan Compiled Law 750.811. Restitution may be ordered as this offense may have resulted in damage to another individual's personal property, physical injury, or death to another individual. This is a misdemeanor with a maximum penalty of 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalty attached?
Yes, Your Honor.
You have the right to be represented by counsel. Today, you're represented by Ms. Tingle from the Office of the Public Defender, but that is for the purpose of your arraignment only. You have the right to have an attorney represent you throughout the pendency of this criminal action, and then you also have the right to have an attorney with you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can request to have the Public Defender's Office appointed to represent you at the expense of the public. Do you understand your right to counsel?
Yes, Your Honor.
Is she requesting court-appointed counsel?
She is, and I'll get her application submitted to my chief for review.
Okay. Ms. Frederick, you have the right to remain silent. So anything that you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. If you stand mute, we'll proceed to trial in this matter. You have the right in this matter to have a trial, and you have the right to jury trial. At the time of trial, you enjoy the presumption of innocence. So that means you're innocent until proven guilty. You have the right to have the prosecutor prove your guilt at a trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to cross-examine or confront any of the witnesses in court that the prosecution intends to call against you. You have the right to call your own witnesses to trial or present evidence at trial that you believe further a defense to the charge being brought against you. Do you understand those rights so far?
Not guilty, yes.
Okay. Okay. The court will enter a plea of not guilty on your behalf. I just want to make sure that you're understanding your rights as well. Do you have any questions about the rights so far?
No, not right now, no.
Okay. Okay. And then you also have the right to remain silent at trial and not have silence be used against you. Are you currently employed?
No, Your Honor.
Okay. Is your home address the address on East Edgewood?
Yes,
Is that the address of Jacqueline Jones Frederick as well?
no, Your Honor.
And your phone number is the number ending in 5112, is that accurate?
Yes,
Okay, your next court date is gonna be a pretrial. You'll get that date in the mail, okay?
Yes,
You need to make sure you revise the court of any changes in your contact information immediately so that you don't miss a court date and end up with a bench warrant, okay?
yes, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
Okay, counsel, you can address bond.
Thank you, Your Honor. I did have the opportunity to speak with Ms. Frederick. She informed me that she was born and raised in Michigan. She's resided in the Ingham County area for the past 6 years. She is a stay-at-home mother of one child. She indicated that she does know the complaining witness is that it's her mom. However, she was not aware that there was an outstanding warrant in this matter until she started looking for a new job. It's my understanding that Ms. Frederick came to turn herself in on this warrant upon learning about it yesterday afternoon and has been in custody since. I don't believe her to be a flight risk. She does have one prior nonviolent conviction from misdemeanor from 2009, in which she successfully completed in that matter. She's always appeared in court when she knew about it and when she was required to be there. Based on the nonviolent nature of the act, her presumption of innocence, the lack of any nonviolent criminal history, the amount of time that's passed since the date of alleged incident in this matter, we would respectfully request and the fact she turned herself in on this, a PR bond in this matter. Thank you, Your Honor.
Bond will be set in the amount of $500 personal recognizance. While out on bond, you have the following conditions. You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. Okay. Looks like we have a victim impact statement in the file that should be addressed by the prosecutor's office to see if it's in the interest of justice to proceed with the prosecution. But at this time, there will be a no contact order in place. And that means that you can't have contact directly or indirectly with the alleged victim, okay?
Yes,
And you're not to be within 2,000 feet of wherever the alleged victim lives, works, or goes to school during the pendency of this action, okay?
yes.
Do you have any questions at this time?
Is the bond for 500?
I'll explain.
It's personal
Okay.
recognizance, so you don't have to pay anything to get out.
Okay, thank you.
No problem. Any additional matters for the record, counsel?
Nothing further. Thank you very much.
You're all set, ma'am.
Thank you.
You're welcome.
Mr. Kane. Yeah. I'll make sure. Yeah. So she calls me.
On the record, in the matter of the people of the state of Michigan versus John Jacob Kane, file number 23-00238 FY, counsel appearance.
Thank you, Your Honor. Amanda Tringle, Office of Public Defender, appearing on behalf of Mr. John Kane for purposes of arraignment only.
Okay, Mr. Kane, today's the date set for an arraignment. I have two files here. Let's see what this is. Actually, I have one file, two violations. It's the same file. It appears that you were before me back on June 1st, 2023. You pled guilty to count 2 of domestic violence. I dismissed count 1 per the plea agreement. You were scheduled to be sentenced on July 27th. I reinstated your bond with the condition for you to receive treatment at Bear River. You were ordered to report to probation, and you did not do that. So you failed to report to probation within 14 days as ordered by the court. What happened, sir?
It was a misunderstanding. I didn't understand that I needed to report to the probation part, and I gladly appeared to him on Monday morning and go, "You just gotta tell me where to go, who to call."
You said you did what on Monday morning?
I said, this probation thing is just a misunderstanding. I guess it wasn't clearly explained to me about this, that I needed to go. I just need to know who to call and who to talk to on Monday morning, and I will appear to them first thing. I don't even, where is it that I go to see them for this probation? Or do I call them, go courthouse, where?
Let's see. The other issue in this file is that while you were on bond, because you're still on bond in this matter, you were not to use, purchase, or possess any controlled substances. I have a PA 53 violation alleging that you violated this term by using heroin back on July 14th, 2023.
14.
The allegation is that you admitted to using heroin on that date.
What is today's date?
Well, today's the 15th, sir.
I'm
You have
still
the right
waiting
to
on,
have a contested, you have the right to have a contested hearing on the bond violation, and you have the right to be represented by counsel at that hearing. If you're found to be in violation of your bond could be revoked pending sentencing, that is, at least. And you also can face a contempt of court order, the maximum penalty of 93 days in jail or up to $7,500 in fines. Do you understand that, sir?
yes.
Okay. Did you ever go to Bear River?
I'm still waiting on a bed. I'm transporting on Tuesday. They finally just now got the bed open.
Gotcha.
But I've had to call them twice a week.
Mhm.
But they've got transport set up for Tuesday afternoon, about 3:30.
Mhm.
They're supposed to be picking me up from Discount Month from Breaks where I work at.
Counsel, you can address bond.
Thank you, Your Honor. I did have the opportunity to speak with Mr. Kane. He informs me that he's been in the Ingham County area for the past 3 years. He's also informed me that he's always appearing in court when required to be there. I am concerned about potential withdrawals with Mr. Kane. And if he remains in custody, I do think he may need some medical attention. Based on those things, we would respectfully request a reasonable bond in this matter.
I think under the circumstances, and Mr. Kane, you and I have had a bit of a history with this file as it relates to you following all of my conditions of bond. And now I have a new violation and I had to issue a bench warrant, which you didn't turn yourself in on the bench warrant.
I didn't even know about the warrant. I was walking to work and one of the officers seen me that knew me and come rushing right up to get me. I had no knowledge of this warrant until this morning because I was looking at him like, well, you have a warrant for your arrest. And when we got here, they gave me like 5 different reasons as to why there was a warrant, but none of them could make sense.
Okay, well, there's a warrant because you were supposed to, there was a warrant because you were supposed to report to probation within 48 hours of your release. 2 weeks went by and you failed to report. The other concern, sir, and you're quite aware of the history that we've had in this file, there's been multiple allegations of the violation of the bond in the past. And although I dismissed your PA 53 back on June 1st, it was not because I determined you were not in violation of your bond. It was because of the plea agreement, and I thought it was in the interest of justice. But there's been situations in where you blatantly violated my bond conditions in the past. I've gone out of my way to assist you, even as it relates to the matter that you had pending that was not connected to this, but was connected to you getting your personal items from the property under an eviction matter so that you could be compliant with my no contact order. And you made efforts to try to deceive the court. I don't trust that if I release you that you're going to do what you're supposed to do. And that's because of your past history here with this file. So I will not be granting a personal recognizance bond. Bond will be set in the amount of $5,000, 10%, which was the bond that you previously had. And you can seek and get whatever medical treatment you need to address your potential withdrawal while you're in the custody of the jail. You will also be ordered to meet with probation so they can provide the court with a substance abuse assessment. Your sentencing date's going to now have to be reset because you never complied with the court order back in June. So that means we won't have an accurate report as to how you should be sentenced at the time of your scheduled sentencing date, which is the 27th of this month. So we'll have to reset the clock on that. And then you can make new arrangements with Bear River. They're gonna have to pick you up from Ingham County if you don't post the bond. Do you understand that?
I can't post the bond, but I can appear, Your Honor, if you would change the bond back to the PR bond, I will appear first thing Monday morning to the probation department.
Oh, we're not negotiating that. I'm not changing the bond. It's $5,000, 10%. And you need to make sure you meet with probation if you post that bond for some reason within 48 hours of your release. Do you understand that?
Yes, how long is this gonna be that this is gonna take? So I know how long I'm incarcerated.
What do you mean that you're not being sentenced to jail time? It's a bond.
No, what I mean is, yeah, I can't post this type of bond. I have no money.
Okay, well then you'll be there until you're sentenced, and then we'll figure out what your sentence is. I don't know what your sentence is going to be at this time. I don't have a report. You didn't comply with my order so that I can get a timely report. So now we have to restart that so that we can get a recommendation from probation as to how you should be sentenced.
That means
Any other
you might as
questions?
well just go ahead and just give me the 90, what is this, maximum 93? You might as well just go give me the 93 days now then, because I can't post
I might
this
as well.
bond.
I might as well just go ahead and tell you your bond is $5,000, 10%. You're all set. Thank you.
Yes. Jail, so.
Thank you, Ms. Tingle.
Thank you, Your